Dramatic changes about false statements and documents. Now, I think most down under visa clients and blog readers are familiar with the strict rules about false statements and bogus documents and their catastrophic effects on Australian visa applications. And we've certainly hammered the point over the years, and our strictness has largely paid off. We've had a few clients caught in the net, but I think all cases it was because of some fairly deliberate omissions of facts, such as husbands and kids they decided to leave off applications. Now, but our scrutiny over checking documents thoroughly and demanding legal correction of errors has meant that we've so far caught each and every single error before it went into the system and led to visa refusals. And being specialists in Australian visa applications from the Philippines, we know the scams and we know the documents very, very well. Am I proud of this result? Well, yeah, damn right I am, and rightly so. This is why I generally respond to client requests for lowered standards with, well, fine. Would you like to take the risk? I generally don't. If you engage an expert, you need to let us do our job. Now, announcement here. Regulation 4020 has got tougher. Regulation 4020, or Public Interest Criteria 4020, or PIC 4020 as it's known casually, that is the legislative criteria that your application will be compared against. It applies to partner visas, onshore and offshore, and prospective marriage visas, as well as child visas and tourist visas, and umpteen others, but those are the ones that we deal with. Now, formally, you risked a 3-year ban if they found evidence of false statements or bogus documents which were material particular to the outcome of the application. That means anything that could be construed as able to influence their decisions and the outcome of the visa application could be seen as material particular. And without getting into arguments about whether your own document error was intentional or not, ignorance or lack of intent don't factor into it. The fact it was Uncle Bong Bong who, lodged the false document information in the first place doesn't come into it. Now, this covers a wide range of error, and our success with this would mean you want to follow what we say. Now, formally, this applied to the current application and applications granted in the last 12 months. Anything prior to that didn't count, and anything not granted or anything which was withdrawn didn't count. If you lodged an application and they caught you out with an indefensible false statement or document, then you could withdraw that application. Now, note that I said formally. PIC 4020 changes. PIC 4020 will now cover any application, whether granted or not, in the last 10 years. In other words, it applies to the current visa application, and it applies to any visa application made, granted or not, in the last 10 years. So no more 3-year bans. You are now in fact facing a 10-year ban on applying for any further visa applications. And that is a very long time, I think we will all agree. Now, whereas you could have previously gotten away with simply withdrawing an application when they caught you out on a lie, that's now been removed as an escape mechanism. Your only real hope is that you can argue there are compelling and compassionate circumstances justifying the grant of a visa despite what happened. And that's not so easy. In fact, in most cases, it's downright impossible. So what does the new PIC 4020 mean to visa applicants? Okay, it means the gloves are off from the department's perspective. Now, we've had a number of clients who've dealt with this by withdrawing their application to avoid a penalty that would have resulted in a 3-year ban. And this has given them time to rectify the situation or correct errors so they may apply again. In other words, in cases where it turns out there was a stray husband out there that they didn't mention, or they had some kids that they didn't include in the application. It meant, okay, they could go and sort that out. They could apply again scot-free. Others have gotten away with false statements and bogus documents on visa applications that they had made by waiting the 12 months out after that visa ended in order to apply for further visas. And others have served their time basically by waiting out 3 years to apply again. Sorry to say, but this is now over. Tolerance is now zero. Make a mistake with the facts either by carelessness or deliberate lying or omission of facts, and they find it and deem it relevant to any criteria the minister may consider when making a decision on an application. In other words, relevant to something that omission, that lie, that document may make them make a decision that they otherwise wouldn't have made. Okay, so it's fairly broad. If they find that, you will risk a 10-year ban on applying for any further visa applications. Visa application from Philippines to Australia. What should you do? First, understand the seriousness of this and understand why we've always given you such a hard time about getting facts right. And note, this is something we put up with. We set high standards, and you get people get angry with us. People get annoyed with us. They tell us they're frustrated. They tell us we're asking too much. They tell us we're unreasonable. We're not. We know how this works, and now, well, it's got tougher, and the penalties are far higher. So you can see why we give you a hard time. But yeah, as I say, firstly, understand the seriousness of this and understand why we give you a hard time about getting the facts right. Now, about issues like including all children, leave kids off, include all addresses, include all travel details. Don't be casual about this. You can't just say, I forgot, so I left it out, or, oh, I didn't think that was important, so I left it out. You must include all of these things. Getting dates right, no guessing, get the dates right. Get the date wrong, false statement. Any errors, in documents, making sure that they are corrected legally, not quickly, not using fixes, not doing anything dodgy, doing it legally, and honestly, truthfully and factually alerting us to any mistakes or omissions, whether accidental or intentional, made over the last 10 years of Australian visa applications. It means if Ning Ning Travel and Pasador Bongs made up a dodgy visa application for you in 2009, we need to know about it. And as I said, not fighting with us when we tell you something. We're trying to save your butt here, basically. Simple as that. And understand that while we will continue to do an outstanding job of identifying potentially poisonous mistakes and omissions in your applications, as we always do, which will now take us more work and more man hours, the provision of documents and information that the application is based on will be, and always have been, 100% your responsibility, and not something you can fob off onto down on the visa and say, that's what we pay you for. You pay us to do a good job. You don't pay us to read minds. You don't pay us to deal with lies and carelessness. It is your responsibility. It will always be your responsibility. Not just what we say. That's the way the law looks at it. It's your application, not ours. And make sure the facts are right. All documents are correct as well as genuine. And make sure when we say, check this form, check this questionnaire, that you do so like your life depended on it. If the wrong information go into an application, there's very little we can do at that point. We can deal with it beforehand. We find out because we discover it, or you tell us. We can deal with it, but not after it's gone in. I suspect most of you can now see the sense in using a professional registered migration agent who knows all about visa applications for Australian Filipino couples. Right? Thank you. This video was brought to you by Down Under Visa, who specialise in visas for Australian Filipino couples. Please visit our website and complete a free visa assessment form. And please watch some of our other videos. Thank you.